going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chipkey! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. I have got a compilation style video for you today. I have put together all of the House of Buckner videos into one. There are 4 clips so far, and as the story continues, I will add them to this video. So, yeah, we're going to get more hearings from this guy. And yeah, he starts as a sovereign citizen. He kind of drops the script a little bit as he goes through more hearings, but that doesn't change it from being kind of a wild story, especially if half of what he says is true. It's even wilder. And that's just half of what he says is true. All right. You've probably seen these clips on multiple different channels, so I put them all into one. So let's do it. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
The court will call the matters of the state of Michigan versus Lawrence Buckner, case number 25S-00103, as well as 25S-00102.
Tiffany Woods for the people.
Good morning, Mayor. Please, this Honorable Court, Kareem Johnson, on behalf of Mr. Buckner.
Thank you.
This is Mr. Johnson, are you representing Mr. Buckner on both matters or just the 103?
Pardon me?
Are you representing Mr. Buckner in the 103 matter as well, or just the and the 102
I believe just the 102 one, but I can.
I think it would be the 103 one you have.
Okay. Oh,
He's just representing him on the 103. That's the only withdrawal that I have and the only withdrawal that I've signed.
Thank you, Your Honor. Assistant Senator Davy Lebo for Mr. Buckner in the 25S and the 25S 102 matter.
All right, real quick. And this never comes, well, at least it hasn't come back up yet. So I shouldn't say the word never. She just said withdrawal, which means that attorney withdrew? Yeah, I don't know why it doesn't come back. The judge signed it. Maybe he had a previous attorney that he took the place of. I don't know. Also, I did take this from a live stream of mine, so that's why you see the comments kind of popping up. I did try to crop out most of it, so hopefully it's not too distracted.
Thank you, Mr. Lawrence Buckner. Can you please state your name? Good morning, Mr. Buckner. You're muted still, Mr. Buckner.
Can you hear me?
I can.
All right, good morning, Judge Washington. For the record, my name is Lawrence of the family of Buckner.
Thank you. Good morning, Mr. Buckner.
Grand Rising.
All right. We're hearing 2 pre-trials today.
Mr. The 102 matter, like to request an adjournment in order to review the discovery and some case law.
No, I think we're going forward with everything.
Mr. Johnson, what is your request?
Your Honor, I was appointed to this matter late Friday, but I've heard the wishes of my client. I likewise do not have discovery, but if he wants to proceed going forward, I asked the court set this matter for a final pretrial and a trial date.
So just so you know, Counselor Johnson, is once this gets set for the final settlement conference, which would mean it's going to trial, there is no plea offer. Negotiations are done. So I just want to make sure that you're aware of that if you're setting that for the final settlement conference.
Mr. Buckner, are you okay with that?
Yeah, and I also want to. I'm well aware of. I'm glad you said that. That if he go ahead and go forward, that there will be no plea offer, and then at this point, I'm going to maintain my innocence as the black God I am, the divine being. So whatever the cause be, I'm going to accept all the consequences, standing 10 toes down. I'm tired of being discriminated against because of my color. Maybe if you would have read the police report correctly, I'm the victim. This is a travesty of justice. I've never seen somebody come to somebody's home and try to run them over with a vehicle and then they go to jail. Yeah, so I'm ready to go to trial. I'm really ready to go to trial. Cause what? White people can just come to black people's house and try to
Mr.
run them
Buckner,
over, and then
Mr. Buckner,
yeah. So yeah, I got a lot of anger.
Mr.
I'm on
Buckner,
the
just
because of this.
relax for me, Mr. Buckner. Relax for me, okay?
Black Lives Matter.
We're gonna handle this in the appropriate form.
See right here. See nobody called me. See nobody called me. See. I'm gonna tell you something, man.
All right. Mr. Lebo, what is it your plan to do with your case? He does.
Saying, I am not 100% sure what Mr. Buckner is requesting at this point.
He wants to move forward with his trial rights, is what he has said.
My understanding is Mr. Buckner doesn't understand that he'd be giving up any potential plea offers in this case, so we would be moving forward to final settlement.
Very clear. He's made that very clear.
And Judge, just to be certain, so on 102, that's Lebo's case, is that correct?
Yes.
And you've already gotten discovery, so I just need to send discovery to Counselor Johnson. Okay.
Yes, thank you.
Final settlement in both of these matters, April 25th, 2025 at 9:30 a.m.
Mr. Buckner, I'll be with you in just a second.
All right, I didn't realize I cut that short. You didn't miss anything. That was just well, I don't think it was his first appearance. I think there was an appearance before that. I just don't have it. That's the first time I remember seeing him. That was Judge Washington. He got arrested between that day and this day. So this happened over the weekend, just 3 or 4 days after that appearance with Judge Washington. I don't remember the exact date. I want to say, you know what? I'm not even going to guess. Let's just say this. Everything happened in March except for the most recent hearing in front of Judge Simpson, and that's the very end. Okay. Magistrate Garwood, weekend arraignments. Let's go.
Jesus is dead. Our daily bread, and forgive us our trespasses, that we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. For thine is the power, the glory, forever. Amen. Most gracious Heavenly Father, today I am being brought before the court for defending my life. Father Yahweh, I don't understand what is going on, how I was shot at and assaulted, and I ended up in jail. I don't understand how.
Mr. Buckner, Mr. Buckner, I really don't mean to interrupt, but you're being recorded. We're on the record.
This needs to be on the record, and you know.
Mr. Buckner, this is Magistrate Garwood. I'm just reminding you, you can continue with your prayer, but anything that you say can and will be used against you. We'll be with you in just a minute.
And thank you, ma'am. Father Yahweh, I have said everything, and you said that the truth shall set you free. Father Yahweh, in front of the whole Washtenaw County, everybody who's watching on YouTube right now, I have been incarcerated for getting shot at and assaulted. Washtenaw Sheriff's Department did not take no statements from nobody. They locked me up. I am locked up for malicious destruction of property after being shot at. A convicted felon was allowed to shoot at me in broad daylight. I want everybody to know that because I said I didn't want to be a snitch, I said I didn't want my name on no paperwork, all my family and friends made statements, and none of my families and friends' statements were accounted for. I am in jail after being shot at and assaulted. Okay, there is no justice for the black man in Washtenaw County. There were ring cameras that were offered to the police. There were multiple victim statements, multiple eyewitness statements, and I'm the one in jail. But I was the one that was shot at and assaulted. So this goes to show everybody, you better give your life to God, because when you're not living for God, there's no rules in the devil's playground. So I want everybody to witness today that Lawrence Edward Buckner Jr., who has been a stand-up guy for all his life, who never wanted to snitch, never wanted to be on no paperwork, you know, this is what it gets you right here. Okay? And I pray to the God of my understanding, I don't care who talks about me through Washtenaw County. The truth is, I am a victim. I was shot at. I was assaulted. And I'm in jail. And there is no way to tell me that there's anything to justify putting me in jail. Every officer that was on my case was a bold case. The neighbor across the street showed a Ring camera, which proves that I did not do nothing wrong. That wasn't taken into account of place. And then I want everybody in Washtenaw County to know that my 17-year-old nephew was taken to jail because he told the police the truth. He told the police that I was shot at, and why didn't the other guy go to jail, and he was taken to jail with me. So,
Ms. Buckner? I don't mean to interrupt, but you hadn't said amen yet. You hadn't said amen in a while. I think you're just making a statement. You're not making a prayer anymore.
Yeah, that's an interesting way to get to put your statement on the record. Just say it's a prayer, and then start preaching. Start preaching your testimony. Yeah, good job, buddy. Good job.
And praying to God.
Okay, so I'd like to
no understanding. I have no understanding of how.
So let me, Mr. Buckner. Mr. Buckner?
Yes, ma'am.
Let me do my job and try to help you, okay?
I apologize, Miss Tamara. Is that how I pronounce your name, Miss Tamara Garwood?
It's Tamara, and like not today, Tamara, but you can call me Your Honor, call me Magistrate, okay? Just let me do my job and we'll get you taken care of, okay?
First and foremost, I apologize, but the one thing I told Miss Apple before I came in here, I said, Miss Apple, I said, I was already out. I just got released on tether for some issues with my girlfriend, right? And I get a charge on bond. The officer told me I was free to go and then said, oh, we're charging you for violating your bond. I'm charged for violating my bond for getting shot at. And I know that at the end of the day, you have a job to do, everybody have a job to do. But
Mr. Buckner, we can't get any of this done unless you let the magistrate speak. We have to take this one step at a time.
I'm sorry for being so excited. I'm sorry for being a lot of anxiety. I just don't know what to do. I am lost, and that is the truth. I am lost, and I apologize.
Mr. Buckner, I get it. But let me do what I need to do and get this moving.
I apologize. Sorry.
It's okay. And hopefully we can get you some answers and figure out what's going on here, okay?
Yes,
You're
ma'am.
here today on WCSD 25-18663. Tell me your full name for the record.
My name is Lawrence Edward Buckner Jr. I was born March 20th, 1980.
I'm going to give you just a little hint as you're going through your court cases. I know you have other cases, but just a hint to you. When a judge or a magistrate asks you a question, we try to ask you really specific questions because remember, anything you say can be used against you. So when I'm asking you questions, I'm going to ask specific questions and I'm just looking for specific answers. So no need to add, okay? I know you have a lot you want to say, but I'm not deciding whether you're guilty or innocent today. I'm just arraigning you, okay? So before we get too far into your case, just a little bit of housekeeping. Courthouse is closed to the public. The public has the right to hear and see what's happening here in the courtroom. So all of our cases are broadcast live on our YouTube channel. When we're done here today, it's going to come off of the court's YouTube channel. May end up on somebody else's, but it'll come off of our YouTube channel. Next, we're doing this by Zoom. If something happens that you can't hear or see me, let me know right away. Otherwise, I assume our connection's working just fine. Next, the camera in this courtroom's in a weird spot, so it looks like I'm not looking at you. I am actually looking at you on a monitor so that I can actually see you. And last but not least, one of my biggest pet peeves in the whole wide world is when people interrupt me. So I try to be respectful and not interrupt other people. but I start to lose my cool when people interrupt me. So just be forewarned about that, because I think you and I are going to have a little bit of an issue as we communicate here. So just please be mindful of that. With that, I'm going to advise you of your rights. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. If you can't afford an attorney, the court will refer you to the local appointing authority for them to make investigation as to representation. Ms. Apple will assist you today. The public defender's office will be in touch with you after today's court hearing. I've signed the paperwork so they can assist you. Because you've been charged with a felony, you do have the right to a probable cause conference within 14 days of today. You have the right to a preliminary examination within 21 days, and you have the right to a trial. Mr. Buckner, do you understand your rights that I have just explained to you?
No,
You don't understand.
because I don't want to be here. I'm innocent.
That's a separate issue. Do you understand you have the right to have a lawyer represent you?
I do understand I have a right to have a lawyer.
And that's at no cost to you. You understand that? Okay. And do you understand that you have the right to remain silent?
Yes.
Thank you. And do you understand that you have the right to have a preliminary examination within 21 days? That's a mini trial where the prosecutor has to demonstrate to the court that it's likely that the crime was committed and that you committed the crime. And you also have the right to have a probable cause conference within 14 days. Do you understand that?
Yeah. Yeah. Yeah.
Yes?
Yeah.
I think he said yes.
Yes.
And do you understand you have the right to have a trial? And a trial by jury, if that's what you wish to do, or a trial by a judge?
Yes. Yes.
Thank you. All right, then we are going to proceed with appearances by counsel. We'll start with the people.
Andrew Childers appearing on behalf of the people.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Buckner. Your Honor, I did have a chance to review the complaint with Mr. Buckner. We would waive a formal reading of the complaint. My client would stand mute at this time, and I'd ask to address bond when appropriate.
Thank you. Mr. Buckner, I'm not going to go through the details of the complaint with you because you had a chance to review that information with Ms. Apple. You'll have more time to review what happened with the Public Defender's Office as your case proceeds. We'll have you stand mute. I'll enter a plea of not guilty on your behalf. I'm going to schedule you for your next court date. The next court date that you can be seen is a probable cause conference, April 3rd at 9 a.m. with Judge Simpson at the 14A1 District Court. That's live and in person, not by Zoom. We will send you a notice to appear. Again, as I said, you're going to receive additional information from the Public Defender's Office. The next thing we need to address in this case is bond. And there are two parts to bond. Bond conditions, those are things the court tells you you can and cannot do. If you violate a bond condition, you're subject to immediate arrest. The other side of bond is whether you can be released today on your own, or whether you'd have to post a bond in order to be released. Before I make any decisions regarding bond or bond conditions, I'm going to hear from the people, and then I will hear from your counsel. And I just want you to know, we did hear testimony this morning regarding what allegedly took place on the day in question. I also have a copy of your pending cases. You have a couple pending cases right now. And I also have a copy of your criminal history. All of that's going to go into my evaluation. I'm going to hear from the people first, and then I'll hear from Ms. Apple on your behalf.
Yes, ma'am. Yes, ma'am. And I thank you for at least being open-minded enough, because I was scared when I told Miss Apple.
Hold on, Mr. Buckner.
I'm gonna hear from counsel, and if there's something that Ms. Apple missed, which I highly doubt, then if you need to supplement it, we'll see about whether she wants you to supplement it. But she's a really great attorney, so let her do what she needs to do to help you, okay?
Yes, ma'am.
All right, Mr. Childers.
Your Honor, the people are requesting a $20,000 surety bond, no 10% in this case. As the court is aware, the defendant was on bond for a stalking and domestic violence case, as well as a felon in possession and CCW case from, I believe it was, that incident date was close to Christmas, maybe the 24th of December. Those were both charged a few weeks ago by my office. My review of the defendant's criminal history is pretty remarkable. It appears to go back about 30 years. He did 10 years in prison, federal prison for weapons charges. It appears that when he was released, he committed some offenses in the state of Indiana And then obviously we have the new conduct over the last few months here in Washtenaw County. The facts of this case are it's not the charge offense here is simply a malicious destruction of personal property, ramming a vehicle into damaging another vehicle. The people's biggest concern is that this behavior happened while the defendant was on bond for what I consider to be much more serious cases. And because of that, we believe that he certainly has a complete inability to follow orders of the court or conform himself, to the norms of society. He represents a danger to the community and to others. And I would ask that he remain in custody while these cases are pending. I suspect, without question, that Judge Simpson will issue no bond bench warrants based on this behavior probably tomorrow on the cases pending before him.
I just want to confirm, Mr. Childers, if you can tell. So I think I have 4 pending cases. I have an aggravated stalking with a DV. I have a weapons charge. I have a malicious destruction of personal property with Judge Washington. And I have a malicious use of telecommunications services with Judge Washington. And from these, it looks like he's actually posted a bond.
My understanding is he posted a bond on the case. So I actually didn't look at, I was focusing on the felonies.
Yeah.
And so on the ag stalking DV file and the weapons case, my understanding, and actually APA Zenda from our office is handling those, and she was Teams messaging me this morning that he had posted a bond on both of those files.
And it's sizable.
Yes. Yep.
Okay.
It was. And so that's normally a $20,000 bond on an MDOP. It's kind of high.
Put your hands down. Put your hands down. Put your hands down.
And so, yeah, my concern is that we have this conduct while on bond, posted bond on serious matters.
Okay. Just so you know, Mr. Buckner.
Yes,
Yes,
ma'am.
Listen to what I'm saying to you. One of the allegations here, the sort of general concept here, what the prosecutor's arguing is, you have an inability to control yourself, to control your actions. I appreciate the jail is a really complicated place to be, and there's a lot of emotion going on, but I'm watching you, and he's just making arguments. I haven't made any rulings yet. You got to sit still. You got to control your body here while this is happening.
Yes,
Otherwise, Mr. Buckner, you're just supporting what
what
Mr.
he's saying,
Childers is
what he's
saying,
saying.
right?
And
Hold up, Mr. Buckner.
Okay, I'm not asking for comment. I'm telling you, I appreciate the jail is not a great place to be and you want to get out. I get that. But if you can't sit still and act appropriately with me when you should be on your best behavior, even
Yes,
with what
ma'am.
Mr. Childers is saying, you're just supporting his argument. You're making it really hard for yourself and Ms. Apple. So sit tight, let me hear from Ms. Apple, and then I'm going to decide what to do. Okay? Ms. Apple.
Thank you. Your Honor, I will inform the court that for housekeeping, as Mr. Childers did discuss, he does have a bond violation, hearing that it appears he's set to be arraigned on tomorrow before Judge Simpson. So bond is denied on that case. However, Mr. Buckner would like the court to know, and as he has somewhat been trying to express to the court, that and I explained to Mr. Buckner, this will come out as the case proceeds, and if he has a self-defense claim of some kind, then we absolutely will assert that defense. But his concern is that these allegations came about after he was shot at by an individual in the community, and there appears to be several witnesses that saw this and different video footage. So he is frustrated at his circumstances, and that his life was put in danger, and he did what he thought was best and has subsequently been charged with a felony because of that. But again, I discussed with Mr. Buckner in our breakout room and meeting him, the process that we will have to go through and having those conversations and reviewing discovery. But based on that, I would ask the court to consider some type of a nominal bond on this case, so that he is receiving credit while he is potentially held on the other matter before Judge Simpson that he's going to be arraigned on tomorrow.
Thank you. My guess is Judge Simpson's gonna be the bigger problem in this case than me. And he's probably gonna take no matter what I do, his action's probably gonna be more aggressive than my action here. Mr. Sutton lives approximately across the street. Is that right, Mr. Childers?
So the address in my file for Mr. Sutton was in Detroit, but I believe that it might be like a girlfriend or something that lives in the vicinity of Mr. Buckner, and that's
No,
why
that's
he
his
has
cousin.
that address.
That's his family member's house.
There you go.
Do you have an address for that, where that Jeep was parked?
Where my Jeep was parked, my Jeep was
Hold on,
parked.
Mr. Buckner.
Oh, no, I'm sorry, where the Cadillac was parked. Do you have that address, Mr. Childers?
One moment, Your Honor.
I think it was 720.
Let Mr. Childers find it, okay? I appreciate you trying to be helpful.
Yeah, 720.
720.
All right, I'm just going to keep this muted for a second while they give out personal information. They're telling him he can't go back to this address. Let's see if that's it.
Thank y'all for your help, man. May God bless all y'all. Thank you.
We're not done yet, Mr. Buckner.
I'm figuring out your conditions. I just have to type them into the computer, so just hang tight.
Maybe we can get another one of those prayers. I like his prayers. They're entertaining. They come with stories.
It's okay. God, you know the truth. And whatever reason you want me to see.
All right, Mr. Buckner, are you ready, or do you need to finish your prayer?
Father God, please just help me. Please give Judge Tamara Good the spiritual sight to see what happened. Please don't let the devil block her vision. Allow her to see with the spirit.
That was a rhetorical question. All right. I'm going to go through your bond conditions, and then I will tell you your bond. Your bond conditions are not in any particular order, just the order on the form I'm going to read from. It's important that you understand those bond conditions so you can comply with those bond conditions. They're as follows: you're not to use, purchase, or possess any alcohol, illegal drugs, or marijuana. Do you understand?
Yes, ma'am.
Do you have a medical marijuana card?
Yes, I do. So I'm able to allow to use marijuana because I actually have been a medical marijuana participant for years.
Okay, it was just.
But I don't drink.
What?
I don't
Okay.
drink.
Mr. Buckner, just a yes or a no
Yes,
question.
ma'am. Yes, ma'am. I'm sorry.
Okay.
I got shot in my head. So please, just some months ago, I'm suffering from a gunshot from the head. So just please keep that in mind. That's why my emotional, I got shot in my head. I got shot 9 times on Father's Day. And everybody, like when I keep saying this all these current stuff stems from me not cooperating or me getting shot. And nobody believes me. Nobody wants to hear my voice. And it's okay. I died twice in my little brother's arms on June 18th, 2024. I was shot 9 times and 1 time in the head, allegedly by Ronell Johnson. And I told the police I didn't want to have nothing to do with the case. They keep coming to my house telling me, hey, you need to participate in this case. And then the last time Deputy Caruso came to my house, and that's why I'm glad this is on record, he said, Mr. Buckner, who did this to you? The very next day, I was charged with domestic violence, stalking, and all these other charges. This is what the prosecutor, Mr. C. Andrews, I want to say to you, I understand that I have had an extensive record throughout my life. However, if you look at the time frame from the things that I got in Indiana, you know why I went to Indiana. I went to Indiana because of my wife and I got a divorce, okay? That was a very messy divorce.
Mr. Buckner, I am sorry, but I'm not sorry. I'm going to stop you. You have this pending DV case. You're involved in other cases. You're making all of these statements. Ms. Apple is probably, I can't imagine what her feet are doing under her desk right now. You're
I don't
creating
understand
a
how I got
record. Honestly, you're creating a record that is not helpful so that she can do her job and so that all the other attorneys in her office can do their job to help you. So don't be your own worst enemy. Again, there's no question on the table right now. And you just keep talking. You're not helping yourself. You're again demonstrating to me that you can't control yourself for whatever reason, whether it's because you got shot or because you just have impulse control issues. So stop talking. Let me do what I need to do. The original question was, do you have a medical marijuana card? You answered it, yes. That's done. We're moving on to the next topic. Do you understand that? Yes, that's a yes or a no. Yes, you understand?
Yes, I understand.
You're not allowed to leave the state of Michigan without prior permission of the court. You're not to commit any crimes while your case is pending. You must appear for any and all court hearings in other places as directed by the court. Do not commit any crimes. You are not to assault, terrorize, frighten, intimidate, threaten, harass, molest, or stalk anyone. You're not to purchase or possess any firearms, ammunition, dangerous weapons, or any gun components, nor are you to be with anyone who has any of those items. You are going to have random drug and alcohol testing with our community corrections department. If you're already doing that testing, it won't be duplicative, but you will have to appear for an intake with them. That'll be what we refer to as standard supervision, and you'll have to present them with your medical marijuana. Do you understand that so far?
Yes, Ms. Gatewood.
Garwood.
I'm so sorry. Ms. Garwood, I apologize. Judge Garwood, I apologize.
No worries. You are to have no contact with Billy Sutton. In addition.
Billy Sutton, AKA Dollar Bill?
Stop. You know exactly who I'm talking about.
Billy Sutton.
You are to have no
real name.
Stop talking. You are to have no contact with Billy Sutton. When I say no contact, no direct or indirect contact with that individual in person or through an attempt to have contact with him. No telephone, email, texting, internet, or social media. Don't send anything to him. Don't deliver anything to him. Don't direct anyone else to be in touch with him on your behalf. I also don't want you going to you having any contact with anyone who resides at that house. I don't want you having any contact with anyone who's visiting that house. I don't want you going to Billy Sutton's home, work, any school, any place of worship that he may attend, or any temporary residence. Do you understand? That requires an answer, a yes or a no.
Yes, ma'am.
Thank you. All of your conditions, they are going to exist whether you're in custody or out of custody. They remain in full force and effect until changed by the court. Do you understand?
Yes, ma'am.
Thank you. As far as bond is concerned, it is clear to me that a lot more took place, and the testimony we heard from the sheriff's deputy had a lot of other people involved and had a lot of other activity that was going on. I would anticipate, based upon what I heard from that deputy, that other charges are coming for other people, not just from you or for you, for that particular event. But what I have in front of me gives me cause to have concern for the safety of the community. It gives me cause to have concern whether you have an ability to control yourself and whether you have the ability to follow court orders. Based upon those, well, you haven't, and you have a bond violation hearing tomorrow with Judge Simpson because of that. So based upon that information.
Jesus Christ, Ms. Garwood, in the name of Jesus.
I'm talking.
Mr. Buckner.
I'm still talking. Remember, I don't interrupt you. You don't interrupt me. That was the deal we made at the beginning. I'm setting a cash bond $20,000, cash or surety, no 10% privilege. I believe that that is appropriate. Somebody could have been really hurt, so.
Right, like me getting shot in the head. And let me tell you something, Judge, since you already set the bond, in the name of Jesus
Mr.
Christ,
Buckner, please.
in the name of Jesus
Encourage
Christ,
you not to speak about any
The
kind of,
bond,
let me
hey,
tell
Ms.
you
Apple, do
something.
you see what Ms.
Right.
Apple, how, like, she just said that a police officer just came in here, gave her testimony. She said that she worried about me being a threat to society when I got shot at. How am
Mr.
I a
Buckner,
threat
the
to
bond
society?
has been set.
Apparently
The
you
bond
did
has
not
been
hear the
set.
statement I made right before that. The bond has been set. Counsel, Ms. Apple, anything further in this matter?
No, thank
Hey,
you.
hey, Ms.
Mr.
Apple, man,
Childers,
what
anything?
actually
I'm gonna have to
happened?
mute you.
She gave me a
I'm gonna have to mute you. You've been muted. We can't hear you. Mr. Childers, anything further in this matter?
No, Your Honor, thank you.
All right, thank you. You are muted. I'm not going to hear from you if you're yelling at me. If you have a question, I'm happy to answer a question, but I'm not going to have you yell at me. I'm not going to have you threaten me. I'll unmute you if you have a question. You're still muted. I'll unmute you if it's a question, but I'm not going to have
Your
you
Honor,
yell at
I
me.
would, on behalf of my client, I would probably
Okay,
ask that we
Ms.
just conclude this
Apple,
hearing.
is fine
We'll
with
talk
us
with-
leaving you muted. That'll complete this hearing. We'll let the jail know that he's done.
We'll talk with him tomorrow too, so.
Okay,
if
sir,
he has
you're all
anything-
set. We're not going to have more comments from you.
Thank you.
You're welcome. Can you let the jail staff know to move him? Oh, he's gonna move himself.
I think he just gave the court the finger.
And I'm a pretty good lip reader.
Yeah,
And I'm
that
pretty
looked like an
sure
expert.
the last comment started with an F and a Y. We can let the record reflect that.
Sure.
All right. All right. So that happened over the weekend. I believe that might have happened on Sunday, maybe 2 weeks ago. And then this happened either the Monday or Tuesday afterwards. Now, I know Magistrate Garwood said he would be in front of Judge Simpson the next day. That did not happen. He was in front of Magistrate Braley. And yeah, we'll just go on with this one.
Attorney Dadouche, do
Yes,
you
sir.
have a violation for Mr. Buckner? Because I did not receive a copy.
I do not. I do
Okay.
not have one. I just looked at JIS and found that there he was charged with something else and assumed that that was the violation.
Okay. I don't believe I have any documentation. Give me just a moment. Sorry, Mr. Buckner.
Oh, I apologize, Magistrate Hillary Braley.
You can. I think she's just trying to find the documentation.
Okay, so Mr. Buckner, unfortunately, I don't have the paperwork that I need to actually be able to arraign you on the bond violations, so I can't arraign you this morning or this afternoon. Okay.
You know what, ma'am? Normally I would, but I'm gonna look at this as a sign from God of my understanding. And I thank you for having the patience to see me at this time. And I understand that you don't have the paperwork. And I hope and pray that when I do see you next, and that the God of the universe will vindicate me. And it will also give you time to look into the mitigating factors of my so-called violation. And I appreciate you. I was looking to come in here to get some type of, but the whole theme of today has been patience. And Mrs. Karma Dadouche, she came to me. I didn't know what I was being arraigned on, and they said the bond violation, and I want to wholeheartedly apologize to the entire, Washington prosecutor office, and you as well, Mrs. Magistrate Hillary, for me being in front of you And I hope and pray that the next time I see you, that you will please look at the report very carefully and in regards to making your decision. You know, I got out on bond and
Well, okay, so sir, I'm just, and I appreciate that you want to talk about the circumstances of what happened, but I haven't actually called your cases, okay, because I don't have what I need to do anything for you.
where is it?
Okay. I am not sure. My understanding is that we reached out to the prosecutor's office and I don't have the paperwork yet. So, that is something that I'm sure the public defender's office will be looking into, presumably Attorney Dadouche. Okay.
Yes, Your Honor.
Thank you. So we will get your arraignment handled as soon as we can, but unfortunately there's nothing I can do for right now. So I am gonna ask that you go to the door, please, and let the officer know.
I would do that, sir. And thank you, Miss Dadouche. And I'm glad all this is on YouTube or whatever. So all my family members know that I was shot at.
I wouldn't talk about what happened, Mr. Buckner. You'll have an opportunity to do that at your hearing, okay?
All right. And God will vindicate me. The God of the universe is chastising me for not walking in his laws and statutes up to my spirituality. And this happens when you can't play sides of fence with God. When you have knowledge of God, it's either you're going to be on God's side or the other side. There's no walking. And the reason I'm here today is because I did not wholeheartedly walk with God. Thank you.
Thank you.
Have a nice day. We'll contact you before your next arraignment.
Okay. All right. Now we're moving into the last part. This is actually the longest part. I didn't realize it was going to be this long. All right. So Judge Simpson gets the last piece and the latest piece of this story, the House of Buckner. Like I said, we're going to get more updates from him. I'm trying to comment as little as possible because this is a long video, but I do appreciate you guys sticking this out, and thank you so much. Let's go.
Court does call the case People versus Lawrence Buckner. Who just stepped out? Pardon? Approach on this matter?
No.
On, okay. State your name.
Lawrence is a family Buckner.
All right. Go.
I do want to say he made bond. You know what? Actually, they do make a reference to a hearing they had in front of Judge Washington. It wasn't on YouTube. We don't have that, so I'm gonna guess that Judge Washington probably let him out, or maybe he just had money to make the bond. I don't know, but yeah, he's out of jail, and we did miss the hearing. It's not my fault. We can blame it on Judge Washington.
Go ahead, counsel. Mr. Johnson, go ahead.
Good morning, man. Please, this honorable court, Kareem Johnson, appearing on behalf of Mr. Buckner.
All right, what are we doing on this case?
Yeah, I have received all discovery and police reports with body camera. We're asking this matter be set for exam. However, Mr. Buckner has, I believe, 3 witnesses that I think we will want to ask the court to take testimony from at the exam. So I'm asking for some extra time to make sure I can get those witnesses subpoenaed to court.
Any objection to that, counsel?
Your Honor, I don't object to the outbreak exam or to defense counsel's request. However, I believe counsel is new on the case. He's not aware of something that comprised the public defender up. Earlier this week, this defendant made threats to the witness at preliminary examination.
Yes.
A new charge,
Sir, you need to face me.
a new charge has been authorized against this defendant as a result of his conduct. And as a result of that new charge being authorized, we are requesting remand. We have previously advised the public defender's office.
Judge Rand Washington is in the office.
Your Honor.
Your Honor, this is,
Sir, I will give you an opportunity to address the court, but you're not gonna interrupt you're not gonna interrupt anybody. You're interrupting. Yes.
This exam was held on Tuesday, and after the victim in the case had testified, Mr. Buckner, during a break in the exam, threatened her in the gallery, and we did end up charging him with threatening to injure or kill a witness. And this is a victim that he was not supposed to have contact with, as she was a victim on the FA case. So in that sense, he had violated the bond by contacting her in court and also threatening her with criminal charges, which is why we would be asking for his bond.
Sir, what did you want to tell me?
Sir.
Well, Mr. Buckner, I'd advise at this point you don't make any statements.
Mr. Johnson, I need to speak because if I don't speak, the prosecutor said they want to lock me up in remand. It's up to Judge Simpson. So I have to present my portion of the truth. If I don't, I'm going to jail. Like, I have a family to support. Please, like, I am not guilty. And this is what I,
well,
okay, okay, on Tuesday, I had a hearing for a situation that I was allegedly accused of, right? During that hearing, it is my belief, so let me just say that, it is my belief that the coerced witness messed up the testimony. So they said that the witness said that I threatened her. I never threatened her. They said that they went to the officers, they had stuff on body cam, sir. No, it wasn't that. If you go on body cam, I was talking to my aunt Sandra Lamont and my family member, my phone was on, and I was talking to them, and nothing out of my mouth said, I'm gonna threaten that lady, I'm gonna get that lady. They have been trying to harass me and my family ever since that I got shot on Father's Day, and I didn't cooperate with the police investigation. I got shot 9 times and 1 time in the head. 2 days before all these incidents happened, please hear me out. Deputy Caruso from Washington County kept coming to my house saying, you need to testify who shot you. You need to testify who shot you. I said, Mr. Caruso, all I want to do is live my life. I got a family. I got my brothers here. I got people that I support. I don't want nobody getting killed. I died twice in my brother's arm. The next day, I got in an incident with my lady friend, and it went from a domestic violence to a stalking. Ypsilanti police officer Tyson came in to Washington County Jail. The very night I was arrested, tried to read me a personal protection order. I said, I don't want to do it, because I didn't do anything wrong. The next day I woke up, I had stalking charge. That was dismissed. That was the malicious prosecution is going on. Please hear me out. Then Jacob Dillon came to my house, tried to run me over with a vehicle. I punched his window out. I go to jail for that at my home. Okay. Then so I come to court, and the prosecutors, Judge Rand Washington is the eyewitness. This same prosecutor, while we was in court on camera yesterday, sir, while we was on court on camera, just please hear me, said Mr. Buckner is threatening my witnesses in court. This is what this same prosecutor said. Judge Rand Washington said, no, he's not. Mr. Buckner is talking to me, and he's not threatening. See, they had already had it out.
Stop. There was a video requested. Does the video show anything?
Yeah, I haven't had a chance to review it. I just got it this morning. But we were informed immediately after the threat occurred. She informed our advocate, and then informed us that it had happened. And then she did a police report, and then we authorized the charges.
Your Honor, may I?
Hey, just a second, Mr. Johnson. Has the complaint's been authorized? Has it been sworn to?
I don't think so yet. It was just authorized this morning at 8 a.m.
All right. Yes, Mr. Johnson, go ahead, sir.
Your Honor, this was not my case. This was the public defender's office's case. My case was dismissed prior to this case on Tuesday. I have no knowledge of this. I have no discovery on this. So I can't effectively address this and make sure my client gets his due process rights in terms of a bond revocation hearing. I understand that this may have just happened Tuesday, and all the police reports and video camera have not been gathered. But I do think it is unfair to address this right now. Mr. Buckner has always showed up to court. He's always showed up to court timely. I think it's best for the attorney who was present at that hearing to handle this bond violation, especially if that case is still ongoing. I just can't effectively represent Mr. Buckner on a bond violation that I did not know was going to occur this morning right now, Yana.
Yeah. Mr. Brown, were you there on that?
I was not, Mr. Michael. First of all, one round that I was not there, Mr. Michael. Daddy was. I'm not sure if this being handled as a bond violation.
Well, they're asking for revocation of this bond because of new charges, I presume, and the nature of those new charges. So that's what they're asking for. I think a couple of things there, and I don't know what there was a request made for video from this courtroom of that date. We got time narrowed down. You need to take your hands out of your pockets. And the request was made. I checked with Judge Washington because she was the judge presiding as to whether or not she had any objection to that. She did not. That was, I think, Vern provided to the people in this case. They have not had an opportunity to review it.
So as it stands now, these allegations that they have violated nothing's charged.
Well, no, it's basically charged. It's authorized at this point. It's just that it hasn't come through the system yet. Okay, so here's what I'm going to suggest, and may not like it, but I think maybe this is the way to do it. The video, somebody from your office, Mr. Brown, was handling his exam, correct?
Yeah.
Okay.
We just talked about it.
He didn't see anything. So what I would do, and I get Mr. Johnson's point, he's trying to do that. What I'm going to do is temporarily take the defendant into custody. I want that video provided to Mr. Buckner. Mr. Buckner. I don't know what's on the video. I did not view it myself. And then have counsel look at the video, and then I will myself look at it when I get a break to be able to do so, and then make a determination if based upon that, his bond in this case should be revoked. I think that's probably the fairest way that I can potentially do. Yes, sir.
Sir, I appreciate you first and foremost for this opportunity. And I say this to the court that upon looking at the video, the prosecutor said that it's when I want the whole court to hear it. I physically said that I was going to threaten and get this woman.
Sir, first of all, I don't want you saying anything about what's going to be that new case coming up. I don't want you saying anything. I'm not going to hear it because you're going to end up hurting yourself. What I have said is you will be going into custody. We will then, and I'm not saying even at this point I'm going to keep you in custody. A video was requested. I'm going to give, the prosecutor's got to look at it. I'm going to give counsel that was handling it at that time an opportunity to look at it also. Mr. Brown has already indicated they spoke with that hearing and he did not witness anything. And I don't know because I was not the judge presiding. So this is the best that I can do to try to figure it out at least preliminarily.
Mr. Judge Simpson, I'm a very honorable person. I'm asking in all due respect. I'm not a flight risk, sir.
Sir, I'm not saying that you are.
My daughter's in the car. Is there any way that I can call my brother so he can come?
Sir, I'm going to expedite it as best I can to make sure that I can look at it, get you recalled back up, and tell you what I'm going to do. But I think everybody has to look at it. Mr. Johnson's not here, so he can't himself look at it, but it affects his case. But the people that can look at it can do that and maybe get in touch with Mr. Johnson. I don't know, but I'm just saying that's the way I'm going to handle it at this juncture. All right.
You don't represent me. Okay. So the guy that represents me is Mr. Gotti. Mr. Gotti is the key factor in you being here.
Okay, look, Mr. Buckner, they'll be able to talk to you back there, but I'll pass the matter. Sir, you need to just quiet down, please.
The court is aware of, I'm gonna send it to the video.
All right. And Mr. Brown's going away. Okay, thank you. Got it.
All right. They set him in custody for a couple hours. They brought him back. I'm guessing Judge Simpson watched the video. We'll see. We'll find out. All right. This is the last part of the puzzle. So let's go.
Court does call the case of the people versus Lawrence Buckner.
Joseph McMillan, people, Your Honor.
All right. Mr. Johnson, you're muted, sir. Go ahead.
May it please the court, Kareem Johnson, appearing on behalf of Mr. Buckner.
All right.
What about that participating in we're doing arraignment?
Yes, I'm going to do the arraignment. And just to bring you up to date, Mr. Johnson, the new case that we were talking about has actually been, I now have the file and I'm going to conduct the arraignment on that charge. So, all right. I don't know if you were informed of that. All right. Your name, sir?
Sir, my name is Lawrence Edward Buckner Jr.
All right. You are before the court on a felony complaint, a one-count felony complaint that alleges that on or about April 1st, 2025, at the location of 4133 Washtenaw Avenue, that being the 14A District Court, that you did influence or attempt to influence the testimony at an official proceeding by threatening to kill or injure a person. It's commonly known as witness intimidation, committing a crime threatening to kill or injure. Not asking you, sir, whether or not you believe you did that offense. Do you understand the nature of that charge, sir?
Yes, sir.
That is a felony. It is punishable by up to 15 years incarceration and or a $25,000 fine plus court costs. Do you understand that? You understand that, sir? And you understand also, sir, that a consecutive sentence may be imposed for any other conviction. You understand that? Mr. Buckner, you can sit down while we go through this.
I'm sorry.
Did you understand that, sir? That a consecutive sentence may be imposed for any other conviction.
Sir, forgive me for my emotional upbringing. I don't know what to say right now, sir, and I truly apologize to the court. I don't know what to say yet.
Well, I just need to make sure that you understand and can answer the questions that I'm asking. I need to make sure of two things primarily. First of all, that you understand what you charged with. You told me that you do understand that. The other thing that I need for you to understand is what the maximum penalties are. Miss.
So there's no video.
You may want to mute that.
So this is my freedom is just snatched from me, and I was understanding in this son's white came with that y'all just talked to me. See, I told you I got shot in the head, so you're not hearing the wrong thing. Okay? And you said about video, but now you tell me no video. That's what I'm not understanding, because the whole basis of my freedom today was Judge Simpson viewing the video, and that's why I need help. Oh, what charge is this? This is the charge of having April 4th and Judge Washington work? Okay. Okay. Attention. I understand the attention. I just, from the time, and I apologize ever since, and I'm a little slow right now, so I apologize to the court ahead of time. Y'all be further ahead of me. Second to original charge. Second to original charge that Ms. Johnson, Ms. Washington want to find out. Yeah. I understand, Judge. I'm sorry, I don't.
Okay, so you understand then the maximum penalties on that charge?
Yes, sir.
All right. First question I have for you is, do you want to be represented by an attorney on this? It's a public defender case. As to the formal reading, you waive any further formal reading of the complaint, stand to you. All right. All right. Defendant pleading not guilty, demanding a probable cause hearing. Court will enter that plea. Set a probable cause hearing, and Mr. Johnson, before I set that date, were you asking for an adjournment of the other case? You were asking for that to be set for exam, were you not?
I was, Your Honor, but based on these new developments, I think.
Stay in jail. I'm not trying to stay in jail, Mr. Johnson. Like, please help me. I'm not trying to stay in jail.
I will.
Like, I don't want you to tell the judge to adjourn something. Then I need to be heard on it, and I could find out I did nothing wrong. I need help. And helping me is not leaving me inside Washington County Jail or trying to put me on some type of crazy bond. Like,
Your Honor,
I need help.
Okay, Mr. Buckner, Your Honor, based on my client's representations, I still ask that the court set this matter for exam. As I indicated this morning on my case, Mr. Buckner has, I believe, 2 or 3 witnesses that we would like to try and call at exam. I need some time to subpoena those witnesses. So I was asking the court for an extra week.
So if we were setting the 15th, you would be looking at, say, the 22nd, you're saying?
Yes, sir, Your Honor.
All right. Any objection to that from the people on case ending in 1120?
No, you're saying that for 20 seconds, not.
All right. So in that matter, preliminary examination will be in person for April 22nd, 2025, 9 a.m. That is before Judge. Well, all right. Right, but I think that will be before Judge Washington. All right, and on that case, his bond would continue. All right. So on the other matter, I'll set preliminary examination and I hear what the defendant is saying. What date? PCC. I set it for the 17th. Card. Okay, then I'll set it for the 10th. I'll just set it out a week. April 10th, 2025, 9 a.m. on that matter. As to bond in this case.
Allegation here is that my client allegedly had some outbursts and witness. I had a chance to look at what was available on the equipment. There was nothing. I'm looking at weakness. Strong was the outcome. Charge with destruction is witness intimidation. That means that he's trying to prevent this witness from coming to court, testifying, trying to change what this witness has. All of it goes to whether that witness would be able to appear in future court. Taking the best heard of the prosecution. Said you've been lying on me. Ms. Evans, my client is not saying he said that. But what the prosecution says that she killed you or something to that effect. She shoots you or kills you. Yeah. Motion is for threatening intimidation is that he has to be doing something to prevent this witness saying, don't come to court, trying to stop this witness. I think even if we hold her based on her, I don't think the prosecution should be able to make out a case that his intent was to try to prevent this witness from showing up, coming to court, intimidating this witness from saying, testifying truthfully. That's what this is. Because I do not believe that he will successfully get a conviction, I'm asking that the court set for my client a personal recognizance bond. And here's the reasons why a personal recognizance bond. You have the ability to have no contact. It has a home in Ypsilanti, 680 box. It's not having anything to do with it. Money witness lives separate. He's self-employed, he raises dogs to sustain himself. He suffers from numerous bad injuries. I believe that what's already been raised that he's been shot a lot of times. So he's got health problems that arise with that. Finally, he lives with his autistic needs he has to take care of. He also has a brother who can help make sure that he returns to all future workmates. But it's a responsible individual. They should. I think the charge here is a strong charge. I think it's a charge that even taken in the light most favorable to the prosecution, they will be able to prove that he probably caused that.
Thank you. Response.
Thank you, Your Honor. In this case, as in many things, context is key. This exam Tuesday. At that time, the victim testified at exam. The defendant pointed a gun and racked it at her while she was working as a security guard. It was after this that the defendant asked to go to a bathroom. While walking out, threatened her in the gallery. She immediately reported this to the victim advocate and the assistant prosecuting attorney. Specifically, this defendant said, "You're lying, a lying fucking bitch, I'm going to get you." This is right after she had testified being threatened with a firearm by this defendant. Based upon this defendant's conduct, Your Honor, people believe that a $100,000 bond, no 10%, is appropriate in this case. This was very clearly an attempt by this defendant to intimidate this witness with regards to the case at District Court at exam. The condition of the bond in that case, case number 5-121, I'm sorry, I may have misread that case number, was that he had no contact with the victim, and here he is in court threatening this victim. This is not taking place in a vacuum. This defendant has a pending misdemeanor domestic violence case. the FA case that was the subject of the exam involving firearm and malicious destruction of property felony case. Based upon this conduct, based upon his extensive criminal history, they frankly have extreme concerns for public safety and victim safety. We're asking that as a condition of the bond in this case, that he have no contact with the victim in Hudson, have a no go-to order as for a residential place of employment. And frankly, Your Honor, is this defendant's conduct which has brought us to this point. And the fact that this threat was uttered during a court proceeding immediately after the testimony of the victim is gravely concerning to people, and to our mind points to a need to set a significant bond to secure the safety of the public and the state.
So I'm respond, John.
Yes, sir.
Obviously, very clearly something different in the prosecution that describes you as an angry outburst. Doesn't rise to showing any intent to keep anyone except that angry outburst. They would make hay and try to charge a witness intimidation. It's not that the person already testified, said she was lying, was angry, it was an angry outburst. But we're not going to try to just hear it, show the prosecution instead. Things that the court takes into consideration is the likelihood of conviction. The likelihood of conviction is, as the prosecution says very clearly, I think that's the case about. And what you have is not angry outburst that's being spun, something based on what they saw in the context, an unproven charge.
But if it were directed at the victim in that case, that irrespective of what's being said, that would be improper context, you'd agree.
That's right. Making a bond with a separate case, and that's exactly what's going on. They can certainly say you shouldn't have said anything, you shouldn't have had an angry outburst. That's a bond violation. That's exactly that. In the context of whether or not they should be charging this case, and with this discretion, they can decide. Context of whether or not they would likely to get a conviction based on that flimsy information they have there. That's not right. So yes, maybe they can say it's a bond violation. They should be actually bringing a bond violation rather than charging an entire case. They can't complain to you and say, "Oh, well, we've got a new case based on that."
So there seems to be a misperception because the victim testified at an exam that somehow this conduct was not the victim. The victim's testimony would be needed at trial. And to make this statement, not only that he accused her of lying, but that he was going to get her. When the same victim has seen this defendant firearm at her and rack the weapons, clearly the intent here was to intimidate the witness in question. So based upon this defendant's conduct, I need a $100,000 bond with no 10% is an appropriate remedy. As an additional condition, Your Honor, should this defendant be able to post gas or GPS tether, it will go conditions as to placement of employment residence to the victim. But very clearly, this defendant
I don't know that I have a name for the.
The name of the victim, Your Honor, is Amy Hudson. That's A-M-E. The first name. Hudson,
Say again.
A-M-E-E.
Okay.
Last name Hudson, H-U-D-S-O-N.
Anything else?
No. What it works is it's on a motion, they respond, they make a response, and it's supposed to stop on
Well, I can actually run my courtroom any way I want, but that's okay. Thank you for the suggestion. I'm going to order standard conditions, including no assaultive behavior or any possession of any weapons or anything fashioned to be a weapon. There's to be no possession of any alcohol, recreational marijuana, or any illegal drug. I will order no contact with Amy Hudson. You're not to go to either direct or indirect or through third parties. I will also indicate that there's be no mention of Amy Hudson on any social media or any use of any type of social media. You're also not to go to that person's residence or employment, or place of employment, I should say. What is concerning in this case is that if what is said, and I disagree with the defense, that there has to be something where they did that there. If said, if what is indicated was said, which oddly is consistent with, in some respects, with the underlying offense and what is said, which makes it even, I will have to say, more frightening if it was said. And that it is said during, even at a recess, but during a court proceeding where the defendant knows he is not to have any contact with that particular individual, is highly problematic and something this court cannot tolerate. Should it be that type of individual, in this court's mind, does pose a significant threat to the public in regard to his behavior. I would also indicate that I don't necessarily believe that the defendant is a flight risk, certainly, but I do believe that given everything that the court has heard, he is a significant danger, if not to the public in general, to this one individual. He may be a particular danger. The court is going to set the defendant's monetary amount of his bond at $75,000 cash sure. If the defendant is released, he is to be placed on the GPS home confinement tether. The court may allow, upon petition, his ability to go to work once that's established, but $75,000 on that case. Thank you.
It's possibly from Judge Washington. It's probably the same stuff that they charge me for right now. Same stuff that they charge me for right now. A prosecutor told Judge Washington that I was disrespecting and threatening her client inside the jail, inside the courtroom. Judge Washington looked right at her and said, "No, you're not." He looked right at me. So I asked you to talk. Judge Washington could have helped me on this. Because they got me charged on. They got me charged, Judge. And so this thing, right, for me to make one statement, Judge Simpson, I'm charged with making a crime in the courtroom, right, sir?
Well, you're charged with intimidating a witness that may have taken place in the courtroom.
Okay, and sir, this is the time that I got arrested and you sent me back here, the thing that I was trying to work on you was, the community of people that was helping me, sir, and I know everything I'm saying because you already made a decision, is that the video inside Judge Washington's courtroom, a Wayne Washington courtroom, was the video that would prove my innocence. The prosecutor told Judge Washington that I was threatening Amy Hudson while she was giving her testimony on the stand. Amy Hudson was on the stand. Wayne Washington stopped the court immediately and said, "No, he's not. He ain't looked at her. He ain't said to her. He's mumbling things to me, trying to get my attention." This is on camera in Wayne Washington court. So now, how do I help myself, Judge Simpson?
Your attorney will be able to get a video of that proceeding. All right, Mr. Buckner, thank you.
Hey, Mr. Brown, Mr. Brown. Yes.
All right. Thank you all so much for sticking with me to the end. This is a longer video than I usually do. So, like I said, I kept my comments to myself. I wanted to just let the video speak for itself. For this instance, we've seen these videos. For those of you that haven't watched the entire thing, thank you so much. For those of you that have, you got it without commentary. Well, for the most part. Hopefully you enjoyed this. And yeah, thank you guys so much for sticking out till the end. I do appreciate it. That's all I got. It's time to go home. I will see you guys tomorrow. Until next time, bye.
Thank you.
No.